Hello, hello, good afternoon. It's 12 p.m. already, Thursday, March 19th, and welcome to our webinar. And thank you for being here today, Jacqueline. How are you? How's life? And how's the world of immigration?
I'm doing good, Marco. Thank you. Thank you for having me. It's a pleasure to be here with you today to talk about E's and L's. I think two of my very favorite categories of visa classifications. So I'm excited. I'm excited to share info and tips and tricks to make or break that could make or break your case.
Same here, same here. And even though, as I always say, we're not immigration lawyers and we do not pretend to be immigration lawyers, I mean, over the last 17 years, and time flies, 17 years, we've learned a lot from immigration lawyers like you who have enlightened us and shown us the way to help you guys win cases, because that's the only thing that counts at the end of the day, winning cases. And let's give you maybe one more minute to our webinar guests. And we're really excited to share today, tips, and I'm not going to say tricks, but the things that we have learned and about what works and what doesn't, especially nowadays with where we have a lot of headwinds, right, in the immigration space. How long have you been
Strong headwinds.
practicing? Oh, yes. How long have you been practicing immigration, Jacqueline?
This is my 20th year in practice, and I have always practiced immigration strictly in that field.
And why did you choose immigration?
Well, when I was in college, I worked at an immigration law firm in the accounting department. And so I was
Oh,
always,
really?
yes. And so
Accounting.
I
Wow. Okay.
started I started there, and then they gave me an opportunity or, a chance to do some legal assistant work. And so I kind of went really growing in the immigration field from very early on. And then I started in law school and I, continued working law school full time, working part time, but it was always in the immigration space. And so I was very advanced. I already had accumulated a lot of experience in immigration. And so the natural progression for me was when I graduated was to continue and continue in immigration. And that's where I've been my entire career.
So you went from the numbers, right, to practicing and helping your clients with all these cases. Well, it's 12:03. I want to welcome you all to the webinar ENL Visas, What Can Make or Break a Case. And our guest today is Jacqueline Villalba. We're chatting now, and why don't we do this? Since you're talking about your background and how you got started, why don't you please share with the audience more about you and your background, please?
Certainly. So Jacqueline Villalba, I'm very happy to be here. Thank you again, Marco. I am board certified in immigration and immigration nationality law. I'm a partner at Harper Meyer, and as I said, this is my 20th year practicing strictly immigration and nationality law. I focus my practice on employment-based visas, both non-immigrant and immigrant. I also handle a variety of family-based immigration cases, citizenship, EB-5. I do some removal work, but the primary focus is on the employment or the business side of immigration. And I'm a past chair of the Florida Bar International Law Section. I have served on the AILA South Florida board for our local chapter. Um, just enjoy what I do. It is challenging, especially in these days, but it's no greater feeling than to be able to help clients with the entire immigration process and set them up here in the U.S. and put them on a path to success here. So happy to be here and excited.
Nice, nice, and thank you for all the hard work and the fighting for immigrants and their rights. So, Marcos Cano, I am also an immigrant, and I happened to start working in the U.S. immigration by chance. Let me give you, a little bit about my background. I've been an entrepreneur and business owner for more than 35 years, so I know what it means to launch, grow, and scale businesses and succeed in business, but also fail in business. That's how you learn. So after 35, after a few years of doing that, in 2004, I slowly transitioned into business consulting. And then when I came to the US in 2009 under an O1 visa, Long story short, the immigration lawyer who handled my O1 petition said, look, I don't usually include a business plan in my O1s for business, but your sponsor is a startup. So I think I want to make the case stronger. Long story short, I ended up getting involved in the business plan. I was looking, to transition and I came from the hospitality and restaurant and food service business. And honestly, I wanted to take a break from that world, which I loved and still love. But then, I got exposed to, business immigration and business plans. And I said, why not? Man, 17 years ago. So in those 17 years, we've done around 9,000 cases. But as I was telling Jacqueline before, I'm extremely grateful. We've learned a lot from hundreds of immigration lawyers. And I'm really excited to always be able to help lawyers win cases and help our clients get their visas approved. I don't know the work and business plans myself. I am like your L executive. I direct and oversee the team. I am very hands-on. I am extremely passionate about delivering quality business plan done right, and with again the goal of getting these visas approved. Having said this, we have an excited agenda for today. We're going to be talking about the post specific requirements. We're going to be talking about L visa requirements, transitioning from to a green card. We're going to be talking about a couple of case studies. And yes, we will have room for questions for the FAQs. But why don't we get started with let's see okay, here we go. Jacqueline, it's all yours.
Thank you, Marco. So for E2 treaty visas, there are three very important areas, right? Or let's say three very specific or very important bullets that we need to know and make sure we understand and we're prepared with. We need to know the treaty, we need to know the post, and we need to know the client. And these are key. And all of this really, you're evaluating this not only at client intake, that's the first time that you're seeing this. Then as attorneys, when you are retained, when the client engages your services to prepare an E2 visa application for them, you're reviewing these 3 points again. And then right prior to submission, you're looking at it again. And why? Why do I say that? Why do I say that there's 3 times, or at least minimum 3 times that you're looking at these 3 bullets or these 3 points is because of how fluid the situation is right now. And you may have requirements that change from 1 week to the next. And if you didn't go back and double check your treaty or double check the requirements at the post, or there was an issue with your client, you may be ready to submit your packet and it could be rejected by the post because it didn't meet a specific megabyte requirement that just changed a week or 2 before you're ready to submit. And E2 visa applications sometimes take months to prepare. Some are a month or 2 to put together, but other clients take longer to develop the business, to get you the documentation. They're going back and forth, even maybe to strategize, decide what they're going to do here, where they're going to invest. Sometimes that takes longer. And so when you initially meet with the client and you say, okay, this is what we need to do, you have to continually look at these points. So treaty requirements and some examples. For example, the treaty with the UK, right? That treaty requires domicile. So in your packet, you need to be able to demonstrate that the E2 visa applicant, the principal applicant, has domicile in the UK. And so this comes up frequently. You may have a client that has dual citizenship. They have the UK, which qualifies for the treaty, but maybe they live in, I don't know, a different country, Bahamas, right? And they've been living and residing in the Bahamas, and they're going to apply under the UK treaty, but they don't have domicile. Well, that's an issue. And so you need to know, that that's a requirement and see how you can tackle that challenge. They may have residency or domicile. Maybe their children go to school there. Maybe they're back and forth, and you can make arguments. But that's something very specific to the treaty. When we talk about treaty, and hand in hand with that is visa reciprocity. That's very important to look at. Because some it may not be viable for the visa reciprocity terms. It may not be viable for the client. For example, the treaty with Chile or the visa reciprocity with Chile. The visas are issued for 1 year, 12 months. And so that's going to require, especially if your client travels frequently, it's going to require them to continually, every year renew that visa. And so maybe it's better to look at a different option other than the E2. Do they qualify for something else that may be a little bit more long term? So those are things that we want to look at when we're looking at, and we talk about the actual treaty, right? So treaty requirements, visa reciprocity. And then also I think, and I kind of bundle it within this point, is visa validity and actual entry time or authorized stay upon entry. And so let's use Chile as the example again. That visa is good for 1 year. But when you enter the US in E2 classification, you are admitted for a up to 2 year period. And so strategically, especially with startups, the principal investor may be traveling in and out, but they may need additional time in the US. And let's say they're coming up on month 10, even though their visa is going to expire in 2 months, they should be admitted for 2 years. And so that might give them a little bit more time to prepare a renewal packet, to continue being able to operate their business here, et cetera. So you have to kind of be cognizant of that and really talk to your client and strategize when we talk about treaty reciprocity, validity, et cetera, so that you can do your planning. The second point that I think is very important is know your post, because every post has different requirements, from formatting to page limitations to megabytes to how they want certain documents. Everyone is different. You'll see similarities, right? And there's a common thread or a common theme amongst them, the minimum requirements. But every post has their way of how they want the case presented. So it's very important to look at that. And that's important to look at the beginning during client intake, once you are engaged and you're starting, and then right before you're going to file. Because again, you may submit an electronic packet and it may get rejected because you didn't follow. And what you prepared it based on what you looked at 3 weeks ago or a month ago or 3 months ago or 2 days ago, and that might have been correct. But if it changed and you didn't double check before submission, it's going to be an issue for the client. And all that's going to do is generate delays. So definitely know your post and the specific requirements for that post. And then the last thing that I feel is very important, we have to know the client, right? And with this, we want to look at two particular points. How was treaty citizenship obtained? Because there are countries who are qualifying treaty countries where you can obtain citizenship through investment. Now, based on the James Inhofe National Defense Authorization Act, which came out or which was passed a few years ago, if you obtained citizenship from a qualifying country based on investment, right? If you obtain the citizenship for that country based on investment, now there is a domicile residency requirement there. And so, for example, Grenada, this was very popular. We were able to use this. Many clients were able to obtain citizenship from Grenada based on an investment, which would then lead them or open the door for them to have an E2 investor visa. And so after this act, now you actually have to have residency requirements. So it's important to ask the client, well, how'd you obtain this citizenship? How'd you obtain when they have dual primarily where they have a non-qualifying citizenship and a qualifying citizenship. It's very important to ask that question and make sure that if it does apply, if the residency requirement does apply, that they do that they are eligible, right? That they do meet the requirement. The other thing that we need to talk to the client about and confirm is, where are they residing, right? What citizenship and where they're residing, because now there is no more third country national visa applications. You must apply either in your country of nationality or country of residence. And so strategically, you may opt for one over the other, depending on processing times. But it's something that you have to look at. So I think these are definitely 3 points that we have to look at: beginning, middle, and then right before. And those would be my top things to look at. Obviously, of course, with E2s, we need to look at substantial investment, origin of funds. Those are the actual requirements. But these are my little tips and things that really can pose a challenge if you did not, make sure that all of this was squared away when you initially took on the case. We can move on to the next slide, Marco. So in terms of requirements, or let's talk about the basic requirements for the E2 treaty. Number one, it's not there, but it's inherent in the name, treaty, right? So we need to have a qualifying treaty. That one's pretty straightforward and pretty easy. But The other points that are very important are substantial investment, marginality, source of funds, and then the position or the type of position for the E2 application. So when we talk about substantial investment, the consulate wants to see, has the client or has the applicant made a substantial investment in the US? And interestingly, it's not defined. There is no minimum dollar amount for an E2 investment. It just, the FAM speaks about a substantial investment. And that could be relative, depending on the business, right? If you have a consulting company that you're starting up, well, that investment is going to be much lower than if you are going to be establishing a company that's maybe selling heavy equipment, construction equipment, trucks, a car dealership, things like that, where you're going to have more inventory, etc. And so you have to look at the investment relative to the type of business. When we talk about marginality, it has to be the type of investment that is going to generate more than a minimal living for the investor and his or her family. So how do we show that? Well, is this the type of business that's going to generate employment for other US workers? And if so, for how many? And so we look at those numbers and that information in terms of when we are studying the types of business. Because if it's too small of a business, or it's a business that can be operated remotely, for example, or operated solely by the principal investor, then that may not be, it may be a good business on the business side or financially for the investor, but it may not suffice for purposes of an E2 visa. So it's definitely important to look and talk to your client about marginality. The other point or requirement we have to look at is source of funds. We have to be able to identify that the principal investor had control of the funds and has invested the funds. Where did they get this money from? Be able to document that they had control, that they invested it, that it was their funds. Funds can be gifted to a principal investor. It doesn't necessarily have to be their savings over time. Traditionally, that's usually the way most clients invest, but maybe you have a younger applicant, maybe a recent college graduate, and a parent gifted them funds to start their own business, and they're going to back them and have them support them while they start their own company, entrepreneurs, etc. And so we have to show source of funds. Where did that money come from? And demonstrate that the principal investor had control of the funds and has chosen to invest them in this business. And then the last point that we look at is what type of position is the individual going to hold? Are they a principal investor? Have they invested funds? Is it a substantial investment? And is it the type of investment that is going to generate employment for US workers? And we look at that as one option versus executive or manager. And sometimes they can overlap because you may have a principal investor that's coming in to fill an executive or managerial position. But sometimes you have an individual who has no ownership interest in the E2 vehicle, but they have the same treaty nationality. And that company is interested in sponsoring them based on the treaty nationality. They don't have to have ownership or participation, or maybe they have very little. There's different ways to structure it, but we have to look at what's the position that the individual is going to fill here in the US. And then we go down that route of evaluation when we're putting these applications together.
Perfect. That is a lot of info to take into account, but every single point is critical, right?
Absolutely.
So thank you, Jacqueline. So I want to briefly share how we at Businessman, or how we think a businessman should address, how post impacts business fund. I wanted to use an example. We do a lot of cases for Italian nationals who go to Rome to do their interview. And I checked yesterday, and this is what the specific website for the US consulate says. They want to see a concise business plan that analyzes the local market and competition, and they want to see the 5-year projections, which is kind of a standard in all business plans. Now, here's the main thing that you don't see in many other consulates. They want projections to be backed up by external sources, meaning no pie in the sky, revenue and profit projections without explaining this is where the numbers came from and this is why we can defend our numbers, which, by the way, is the standard one that we use regardless, because when we write a business plan, we're always thinking ahead. What if someone challenges this business plan? What if the E2 is filed through the USCIS and there is an RFE challenging the numbers? As you know, when they challenge the numbers, they don't do a technical analysis. They just think, oh, this company looks whatever. The numbers look not credible. So it's That way, it's relatively easy to come back and explain it. This is the rationale behind the numbers. But then, very important, equally, a concise breakdown of the startup costs necessary for the business to become operational, which is, by the way, the standard that we believe all business plans should meet. Meaning, as a tech clients, we want to show in the business plan that the company is ready to open its doors tomorrow. All we need is the visa approved, or even better, when, of course, under the guidance of an immigration lawyer, the business can start operations before they to file. That requires planning, coordination, so that the E2 investor, does not end up doing something that they should not be doing. Anyway, another important consideration, also in the U.S. consulate in Rome, tab G for marginality, only 20 pages, and within those 20 pages, they want to see a business plan. So we've been seeing over the years how this trend where, for example, now we write 3-page business plan for Madrid, 5 to 8 page business plans. And quite frankly, I prefer those plans because look, you don't need 50, 80 pages. I mean, it's, a good communicator doesn't need a lot of pages. It can be challenging though, of course, but it's key to keep in mind these limitations that immigration lawyers have when they are preparing cases. Now, the other thing that I wanted to talk about is when there are cases, Jacqueline was talking about this, the executive or manager, especially the E2s, all right? What we do with in the business plan is just like with the first Trump presidency, where Baja was, left and right everywhere. We use a Baja or Buy American, Hire American style arguments, right? Showing that this manager or executive is going to hire Americans, right? They're going to train US workers. And that's what actually happens. I mean, you have these foreign managers who bring a very unique and specific expertise and industry knowledge. And they're going to be training US workers on how to do things according to the company's policies and so on. Now, when it comes to substantiality, in line with what Jacqueline was saying, it's not the same when you file in the, in one consulate versus the other. Each U.S. consulate is like its own kingdom. So we know, for example, for a fact that when you file an E2 in London, maybe 100,000 is not a lot in London, but in Bogota, yes. So it really depends on the consulate, right? Now, regarding also the substantiality, it's key again to show that the committed funds are sufficient to make the E2 entity operational. And look, the type of business, as Jacqueline was saying, we have seen $30,000 investments approved and $400,000 investments denied. So really, there is no hard and fast rule, as you know. And last but not least, when it comes to marginality, we aim to show that the E2 entity will not be a marginal one, either by showing that it will generate more than enough income to provide, more than a minimal living for the treaty investor and the family. However, we've done cases where, for whatever reason, the type of business, maybe the E2 investor is a wealthy investor. They have other sources of income, and their particular business is not, very profitable. And in that case, we show that they will be, the E2 entity will have the future capacity to make a significant economic contribution, mainly through job creation. So we have actually handled cases where the E2 entity creates tens or even hundreds of jobs, even though the profits are not that fantastic, but we show a lot of impact on the U.S. economy. So you're next, Jacqueline, go ahead.
So let's move to the L visas, which is our second main classification that we wanted to discuss today. So for the L visa, as many of you may know, is 3 main requirements. Number 1, a qualifying corporate relationship between the foreign entity and the U.S. entity. The second main requirement is demonstrate that the individual that will be transferred to the U.S. Has been functioning in an executive or managerial capacity for at least 1 year within the 3 years prior to filing. And then the third requirement is demonstrate that when they get to the US, they will be functioning in an executive or managerial position here. And with the L visas, there's different requirements in terms of preparation if you are establishing a startup here in the US or if the individual is being transferred to an established company. And so difference is, both, and in my practice, if it's an established company, depending on the size of the company and the position, we may not necessarily include a business plan, a formal business plan, maybe a more condensed business plan, but not necessarily a full formal business plan when it's an established business. If they're coming to launch a department or a new project, then maybe we'll have some, a very condensed, maybe a 3-page write up as to support what they are going to do here in the US. But when it's a startup company, business plan is one of the most important documents or pieces of evidence that we have because we need to show, is this company going to be viable, and how is this individual going to perform in an executive or managerial position at the end of that first year? What are they coming to do? And all of that information is built into the business plan, right? The business plan talks about what the company is going to do, market competitors, barriers to entry, challenges that can be that can arise, how they're going to attack those challenges, and then it also provides financials, right? A glimpse into how is this kind of company going to benefit the U.S. economy? Well, it's going to have revenues, it's going to pay taxes, it's going to have employment. All of this information is built in there, and USCIS looks at it and takes a look and really takes that and uses it for purposes, for when they're adjudicating the petition. It's not just submitting the forms and proof that they were employed in an executive or managerial capacity, and here's the idea of what we're going to have. You need to have good, strong evidence of what's going to be, what's going to happen here in the US once they get here, or what's already has been started, and how are they going to further that plan. So definitely in a startup, we can't get around that business plan requirement. For L's, in contrast to the E's, when we talk about investment amount, again, in comparing them, there's no minimum requirement investment in the E or the L. But for the E, the regulations speak of substantial investment. There really is not that qualifier for the L visa. But we always tell clients, how much money do you need to start up this business? What is it going to cost to get this business up and running, or to purchase a business? Because we have clients that maybe are interested in purchasing an existing business. And so you really have to look at that. And although there is no minimum investment amount, you're starting a business. So there's going to be an investment of funds. And so document that, be able to really identify that. And that is built into the business plan, and not only the business plan, but through your letters of petitioners, through all of your other supporting documentations for your application. The other point that we always have to really specify and really detail are the job duties of both positions, right? So you have to document and demonstrate the specific either executive or the specific managerial duties that the individual performs abroad, and then the specific executive or specific managerial duties that the person will perform when they get to the United States. And general descriptions aren't going to cut it. It's not going to get approved. You're going to get an RFE. You may even get a notice of intent to deny. And answering those are not fun. It's a lot more work. And so if you really spend the time, you sit with your client, talk to me, tell me, what is it that you do day to day? You may have a general idea, and most of the, you may have, a CEO or a director of marketing or, VP of finance, where you're going to have a general idea of their day-to-day duties, but really sit with the individual and ask them, tell me about your day. What do you do on a weekly basis? What do you do on a monthly basis? What are, some duties that you do quarterly or yearly, and really specify those in. When we really hone in on specific details, it shows, and the cases are just, the support letters are stronger, and I think it helps us avoid the RFEs.
100%, 100%. And this is a great segue into how we help lawyers, right? With these L petitions, I always like to know the origin of things. So years ago, I learned that the L visa was created in 1970, right? But the interesting thing is that it was created for large, big corporations. It was never intended for small businesses. So in the United States, most L's, it is my understanding, are blanket L's, where you have these companies with millions of dollars of revenues, and those don't need a business plan, right? So,
Correct.
but then later on, a few years later, they created this exception, the new office petition for companies that have been active, even either startups or companies have been active for less than 1 year. And then you have the existing office where a company has been operating for more than 1 year. So when we work on L1A business plans for new office petitions, as I like to say, we're always juggling, with business realities versus immigration expectations. Remember, I
100%.
have been an entrepreneur for 35 years. I know how our small business clients think. And this is a reality of things, of how small businesses operate. In a small business, everyone does multiple jobs. That's how it works, right? In most cases, especially if it's a new company, job titles don't matter really, but this is what happens. The USAID thinks that small companies are neatly arranged and very structured and organized. That's not how it really works. It's, and they also think and expect a very well defined and documented roles and responsibilities. So this is what happens. And this is also based not only on my personal experience, but with my companies. But I've been a business consultant and business coach for years. A small businesses, they don't even have time to write down job duty. That doesn't exist. So with AI today, what's happening to you guys, immigration lawyers, is that when you ask a client to provide you job duties, they go online, AI, and then they send you a generic list of duties, right? So that's one of the challenges. Second, look in the real world, small companies, they don't even have offices and sometimes no employees, right? I mean,
Mhm.
by definition, the small companies stay lean by hiring part-time employees whenever it is really and strictly necessary. But as you know, for the L visa petition, you need subordinate employees and different layers of subordinate management and all that stuff. Third business reality, small business owners work with no salary. That happens very often until their company, generates sufficient cash flow to pay them, right? Or even the staff members may be paid below market wages, but that doesn't work for DL. So the USCIS expects that those managers, executives, subordinates, frontline employees, they earn market salaries. The fourth challenge is when it comes to finances, many small businesses are launched and operated with very little money. When I launched these business plans, my investment was $10 on an IKEA desk. That was it. I already had my laptop. So that was it. So, but forget about it when it comes to NL. They want to see plenty of capital, not only to launch the business, but they're looking, at least in our experience, into the entity's ability to pay the beneficiary's salary. So it's really showing that there will be sufficient capital there. The second reality that we see is that in the business world, especially today, companies are flat. You don't have all these layers of people reporting to people and managers reporting to more managers. That's so 1970s. But again, that's when the law was written, right? So they expect to see a triangle where you have, especially when it comes to L for executives, and three layers where you have the executive on top, then you have a middle manager, and then you have the frontline employees reporting to the manager. So this is an example of what, this is a redacted case, of course. Um, the typical case that we see here, or typical type of org chart that we like to show, because we believe that a detailed and a strong org chart tells a detailed story, right? This shows the officer, the different layers, who's going to be reporting to whom, and so on. This is an example for an executive. This is an example for a people manager, right? Which is the other category we do business plan for. And then we have so you have here the presidents. By the way, you have a project manager consultants reporting to the president, and then you have the frontline employees. And then you have the functional manager. This was an interesting case where the applicant was the sole employee of the US entity. But you see all these green and blue boxes. It's all the supporting staff. This was a joint venture in the airline industry where that was a very pretty interesting one again. Only one staff member for the L entity. Job duties, I don't want to take a lot of your time explaining this, but um, getting those job duties right is more an art than science, right? We believe in using
Not the
the,
title. Like
exactly,
Marco's, yeah, it's not the title. You got to really tone in on those duties.
exactly. It's not the title. It's using language that jives with the classification. I mean, we've seen cases where the executive or the job duty for the executive uses the word manage. I believe that creates confusion and vice versa. So whenever there's an executive, we believe in using words like directing, overseeing, right? Um, Same for manager. A manager manages, right? The importance of making sure that there's always consistency when it comes to job titles, right? We believe in when there is a finance, um, there's a finance position for an executive. Why call it manager? It's an executive. Let's call it director or CFO. A job title that elevates, even though, as Jacqueline said, the job title doesn't count. If it doesn't jive with the job duties, it can create confusion. That's at least what we believe. Um, it's important to show the subordinates and superior relationship, who reports to whom and how. And as Jacqueline said, avoiding job duties. And more importantly, over time, we've seen how they want more and more details, as if the officer was shadowing the beneficiary, like throughout the day, and understanding what time do you meet with your staff, and what time do you have coffee, the coffee break, what time do you sit down to think about the objectives and that type of thing. So really breaking it down into the day to day. Let's talk now about the transition to the green card. We only have a few minutes, Jacqueline, so go ahead.
Well, the L is a direct path to green card, or can be a direct path to green card. Generally, if it's a startup, you'll come in, or the client will come in for 1 year. Depending on how they are developing the operations of the company, usually obtain an extension for 2 more years, and they may be ready for green card and that in that 2 year period. At which point the company in the US can sponsor the green card. So when we say direct path, it's an easy continuous flow, right? You entered with the L, you got an extension, you moved on to green card, all within the same company. The E may have a very similar path, it may not. And so this again goes back to our very first slide, when you know your client, right? And at client intake, you have to have several conversations with your client and ask, what's your short-term plan and what's your long-term plan? Because if the long-term plan is for the client to get a green card, then from the beginning, you need to do more strategy, not only on the immigration side, but on the business plan side as well. Okay. And you need to build in these projections so that this business plan can grow and be sufficient for the long-term immigration plan, right? And how do they implement that? And so if you strategically, you may originally or initially enter the US on an E because you have the qualifying treaty. But that company may be a subsidiary or a parent to a company abroad, at which the investor is also functioning in an executive or managerial capacity. So your underlying qualifying corporate relationship that you need for the L or for a green card and the EB1 C category, it may already exist. You may just not necessarily use it from the get-go. And that would be strategic, right? Because maybe it's a business that is not going to be able to be developed in 1 year. And if you did an L startup, you only have 1 year to develop. Versus if you come in on an E, maybe you have a little more luxury of time. You can go developing it a little slower. And you're going to need that additional time to really strengthen it to then be able to file for green card. And so this goes back to slide number 1. Know your client, have that discussion with the client, talk about short term and long term, and then see see which path is the most viable for the transition to green card. And so, Marco, I think you have them a little bit detailed there for each of the ones that I just mentioned.
Exactly. Exactly. Remember, I'm not an immigration lawyer, and I am not, will not never pretend to be one. And we never provide immigration advice. However, having seen thousands of cases with hundreds of immigration lawyers, and um, I am an immigration lawyer, and I like to read the policy manual, and I go to a lot of conferences and I learn from the panelists, and I familiar with the PAM, with the, not the PAM, the FAM. And so from a businessman, businessman's perspective, I always wonder why more people don't do the E to green card route. Why? If I'm doing the L, the office petition, I only have 12 months, but in reality, I have 9 because the 9 month mark, I have to call Jacqueline. Hey, Jacqueline, let's get ready for that, for that renewal petition. And then by that time, it's really, if you haven't grown your company, if you have not hired sufficient people, yes, you still have some time, some weeks, but it's really hard. I think that in addition to that, it puts a lot of pressure on business people to grow this business like crazy in 9 months. Whereas if you have,
More time.
if you have only two, you have more time, you can make business decisions without the pressure of making the USCIS happy with all these requirements. Anyway, when we work with lawyers on a need to business plan with the goal of transitioning to a green card in the future, we make sure that there is from the beginning a qualifying relationship, right? And then when it comes, when we go into the future, it's all about showing and proving that the beneficiary is either an executive or manager, and again, we have the people manager and the functional manager, and those are two very different things. Now, the L to green card, which is the most common route that we see out there, it's all about, do you follow the business plan? You spoke about it a little bit. Again, prove to me, I am the USAIS, that you have been actually doing the work of primarily doing the work of an executive, people manager, or functional manager, right? So clients usually ask, oh, do they check the business plan? Do they, if I projected that my company is going to have revenues of $1 million, and will they check if we exactly made $1 million? What if revenues are $999,000? Will I be in trouble? I say, look, it depends. Talk to your lawyer. But what we have seen over the years is that the one thing that the USCIS is really looking into is, you said that you're going to be transferred as an executive. Show me that you have been doing the work of an executive or manager and people manager or functional manager. Revenues and profits, they're important, but things happen in business. You may have even a very conservative plan, but things happen. You got delayed, the market changed, a recession hit the US economy, things happen. So your revenues and profit might not be as good as they were projected. I believe, based on my experience, that the important thing is showing financial viability, right? The company can continue to function from a financial perspective, and yet show me that you are doing the work of an executive or a manager. So again,
Agreed. I think,
yes, go ahead.
Mark, it's very important to look at that business plan at time of renewal, at those 9 months, if it's a startup, or then again when you're at the green card, because stuff happens, right? If COVID taught
Exactly.
us anything, is that plans that we started weren't able to be put in place. But if you have a reason and you have an explanation, and sometimes, and we've worked on this
Exactly.
together, where we started with one business plan with a set of projections, and then we've gone back and I've said, Marco, we need help. We need help with these projections because A, B, and C happened. But X, Y, and Z is going to happen now. And so show how,
Exactly.
even though we projected this originally, we've had to shift and it's still viable because of X, Y, and Z. And so you may need a second business plan or a modified business plan. But
Exactly.
definitely you have to look at it because the immigration officers will look at it. And if you don't have a good explanation as to what happened, that may mean that you're not really functioning in an executive or managerial capacity, right? It kind of is all related. And so you have to go back and you got to look at all the pieces of your puzzle and make sure that they all fit nicely together, in order to really present the best case and put the best case forward.
Great point. I agree with you. It's about explaining what happened, providing a credible and arguments, right, backed up by numbers. And perfect example is after the pandemic, we did a lot of E2 business plan updates and renewals. And, of course, we had to explain, hey, that
Correct.
business didn't go as well as planned, not because of me, but because of the economy, right? That type of thing. So one of the issues that we, over the years, complain a lot about is when we're doing either the initial or the updated business plan for renewal. Oh, we saw a lot of bad bookkeeping and bad financials, messy financials. So after complaining for many years, we decided to do something about it. So what we're doing now is we have a separate service where we work on clients' financials to make sure that those financials are clean, organized. Why is that important? Because most CPAs and bookkeepers, they don't have an idea of, the E1, the E2, the L1A, but not only that, CPAs focus on minimizing taxes legally, right? So that's results, for example, in many cases in margin on companies, right? Because they want to show as many expenses as they can so that they can their clients or the E2 investor can lower the taxes, and they're super happy until they talk to the immigration lawyer and say, wait a minute, your company is losing money. What's going on here? So we have a service where we help we make your life easier with good bookkeeping that checks the boxes of the specific visa category. Now, let's talk about two cases we worked on together and L1A. Maybe you want to talk, describe a little bit what this business was about, Jacqueline?
Sure. So this was a case that Margot helped, and we worked together on the business plan. It was a company that was established, a startup company established in the U.S. To import herbs and other agricultural products from Colombia to the United States. And the challenge here was two in particular. Number one was because it was import and distribution, the client, at least initially on startup, wasn't really going to hold the goods, right? They weren't going to be holding the basil and the oregano and the
Mhm.
spices and all of the herbs that they were going to import. It just logistically it didn't make sense. It wasn't part of the business model. But it can't just be an import-export company, right? You have to have a structure. We got to go back to that.
Exactly.
What is the requirements for immigration and what are the business realities? And we kind of have to come to a happy medium. And so we worked together to establish, and we sat down with the client and said, okay, well, these are the things that we're going to need, and talk to me about what you need in terms of business. And so where was that happy medium? And the plan eventually was to grow, but it was a concern that if it was going to be too small at the end of 1 year, we may not get the renewal. And so back and forth and sitting with the client and really, where can you grow your business and really hone in on what the plan is here. It's not, I want to import. Well, we need more than that. And so, and we can't talk about that 9 months in after approval, right? We need to talk about that from the beginning because you're going to blink 3 times and your 9 months or your time for
Oh,
renewal
yes.
is going to be here. So this was a challenging case because in the reality, the business reality, the traditional employees, things like that, it wasn't there, at least from the get-go. But their plan was to scale, at which they did, and they've been able to really develop a full-fledged distribution company here. But it took time. It took time to do that, and we had to build that time and that explanation into the business plan, obviously into the L1 petition letter and all of the other supporting documents. But the business plan really helped us support, and looking at other, competitors, industry, things like that. It really helped give it the support or the backup that it needed when we said, hey, this is why we need this time. This is why we need an extra 2 years for an extension, et cetera. Here's what we've done. Here's where we're going. And all of that was with the business plan.
Exactly. And the core of a business plan, and this is something that I always share with clients and immigration lawyers. In 17 years, I have never seen a nail case challenged by the USCIS because they didn't like the market analysis. They didn't like the marketing plan. They really look into the org chart and again show me credibly that if you're coming as a manager, which was this case, the beneficiary came as a manager, right? And what we did was we focused on building a credible org chart where we looked at the operations. Okay, what do you need to operate the business that import herbs and then you distribute them to supermarkets? Well, you need a warehouse, right? You need someone to place the orders. You need someone to coordinate the shipping. You need someone to receive the orders. You need someone to store them, and then you need someone to coordinate shipments. So we asked, well, who's going to be doing this and this and this and this, and so let's build an orchard where we will not show that the owner or beneficiary is going to be doing everything. So we should someone and then you need someone to do sales. So we showed a sales manager with a sales associate and then a warehouse manager with a warehouse assistant, and those two managers reporting to the L beneficiary which was a manager. So that was an interesting case. But let's talk about the E2 case. It was an interesting one as well. Go ahead, Jacqueline.
Yes, so this E2 visa that we also worked on together, the challenge that this one presented was that they had this great plan, but they needed additional time to develop the actual day-to-day, the actual business. The business wasn't ready to open its doors. So that always is a concern, right? The consulate's going to look at and say, well, is it viable? Are they ready to go? How much longer do they need? And so it was a substantial investment. It was $120,000 investment, and the funds were fully committed, invested, fully committed to the enterprise. However, not all of the funds were used. In fact, a significant portion of the funds were not used and were in the company's account. And so, but what we did was identify what the investment funds that were in the account were going to be used for and provided timelines for when these funds were going to actually be spent. And it wasn't just a timeline and a description. We had contracts and letters of intent. We had, documents to support when these funds would be released from the account. And the consulate agreed and said, okay, it is viable. I think it's important to know in particular this case specifically. The Foreign Affairs Manual specifically says it has to be a real and active business if the visa is issued. So you don't necessarily have to you have to convince the consulate that if the visa is issued, this is going to happen. You can't just have an idea and then uncommitted funds in an account. But this case posed that challenge because they had only spent a little bit. Ideally, we want to spend all the funds, right? Because it makes our case easier, right? It makes our work as immigration attorneys easier if the client spends all of the funds that they need to start up. But that's, again, we go back, that's not business reality all of the time. And so here we really identified what these, we've earmarked, this 10,000 is going to be for this, and this 20,000 is going to be for that. And, we identified what the specific remaining funds were going to be used for and documented it, and the consulate accepted it. And so that's how we were able to get around, that particular challenge of not really spending, as we say, the investment funds.
Exactly. So it's all about explaining in detail. As I like to say, we don't write immigration business plans, we write children's books. So explaining in detail how things are going to happen. So we have only a few minutes for questions. So let me, here you have Jacqueline's and our information. Let me go ahead and see where we have, hold on one second, the questions, Q&A. So we have two questions here. How many staff do I need to hire for an LNI office petition? Thank you. What are your thoughts, Jacqueline?
Well, interestingly, the regulations don't require a minimum number, but clients always ask, how many do I really need? And we have to look at what does the business need. We have to be able to meet that definition of executive or manager. What position are you here, and justify it? And, are you a functional manager? Look at Marco's example that he indicated, where they only had one employee in the US, but they had other individuals, subcontractors, et cetera, that this person oversaw, right? And directed them so that these individuals could perform the operations of the company. If you're an executive, you're going to probably need more individuals underneath you because it's just the nature of those duties. The executive is more performing at a higher level, maybe more of a bird's eye style of overseeing management, et cetera. So there may be, in that scenario of an executive, more individuals. Do I like to say a specific number? No. Is there a specific, go-to? Not necessarily. We may see cases where 5 or 6 might work. I don't know about today, 5 or 6, maybe. But I guess really, if you hone in on the duties that those 5 or 6 do to explain and demonstrate how the person on top of them is a manager or is an executive, that may work. Obviously, the more employees you have, the easier it makes you those arguments because you can show, who's doing the day-to-day functions of the business, and that way it alleviates the executive or the manager from doing the day-to-day, especially in the startup. Like Marco said, startups, individuals wear many hats, but for immigration, it can only be the executive hat or only the managerial hat. And so you have to be able to show and really, demonstrate who's doing that day to day so that the individual that was transferred can focus solely on their executive or managerial duties, whatever it is that they're assigned.
Exactly, exactly. The way that we answer this question is clients ask us, of course. So we have a two-part answer. A, as your lawyer, we're not immigration lawyers. However, the number is not a number. It's a concept, as you said. It's let's look at what your company needs, but at the same time, we always ask how are you going to be classified? Again, executive, people manager, or functional manager, and let's look at what does it really mean from a legal perspective, and let's make sure that the staffing plan is aligned with that definition and that it's this is equally important and that you as the beneficiary you're committed to implementing this plan because we have to be strategic. This is again talking about a new office petition, right? You have to think 12 months down the road. The biggest difference is that with the initial filing, with a good business plan and a good petition, you can get approved. 12 months down the road is going to be about show me the numbers, show me the financials, show me the people that you actually hired, show me what they're actually doing. So you have to be able to prove that. So it's already 1:01 p.m. If you have to leave, that's we understand, but we can you stay a few more minutes, Jacqueline?
Sure, of course,
Okay.
happy to do so.
Perfect. Thank you. So the $1 million question, Jacqueline, what is the minimum amount of investment that I need for an E or an L visa? Let's begin with the E2 that I think that this is the first time that someone asks you this question, right?
So it's very similar to the employee question, right? What is needed for this business, and what type of business are you starting up? Remember, for the E specifically, it has to be a substantial investment. And so if you're talking and your business plan shows that what you need is $5 million to invest to start up this company, and you invest 100,000, that may not cut it. 100,000 is a substantial investment, but the consulate may not see that that is going to be viable, because how and when are you going to invest the rest to really get this company up and running? Yet if your investment, if what the requirement is 100,000 and you invest the full 100,000, then you have an argument that it's a substantial investment. You invested 100% of the startup costs. So there is no minimum. The regulations, again, do not specify a minimum amount of investment for the E or the L for that fact, but for the E specifically, they don't specify a minimum amount of investment. You have to look at type of business. What is it that you're going to do here? Now, in addition to what is the type of business and what, here business realities, what is needed to start up or maybe purchase the business, and we look at that and we evaluate those numbers. You also have to look at the post. And this was one of the bullets in the first slide, know your post. Because as we mentioned, I know Marco specifically gave the example of London and Bogota. And London is a strict post. They look for higher investment amounts. Again,
Exactly.
they're not looking for a specific minimum, but if you invest 50,000 in London, you may get pushback. You may or not. It depends on the presentation, depends on your plan.
Exactly.
If is 50,000 all that was needed to start up? Has it already started up? And have you invested the 50? You may be able to convince them. Yet if you go to Bogota, possibly. If you go to Canada, possibly 50,000, they don't even, ask a second question. So London specifically, in my experience, has always looked for higher investment amounts. Again, no
Yes.
minimum that they've specifically said. We don't have information says, well, we look for 200 or we look for 2 million, or no, we don't have data like that. But traditionally, the smaller investments are, I guess we could say, they're more scrutinized in London
Exactly.
specifically. And so we take that, and so we look for investments or businesses that are more substantial or higher in dollar amounts. But again, there's no minimum. That's the beauty of the E2. You could have a small business, 100,000, 120,000. That could be a very successful E2 visa application, just like you could have a $5 million, and that could be a substantial and successful E2 application. It's really what
Exactly.
the investor's plan is for the US. And again, goes back to sit with your client, sit with the applicant, talk to them, really ask them questions about their plans here, and then use that information to build your case.
Exactly. Now, there's one question that over the years we have learned is very effective when clients, of course, clients are looking for certainty and
Absolutely.
they're thinking, okay, just tell me how much I have to invest and I will make it happen. So the question I ask, then we ask them is, look, Let's forget for a minute that you're applying for a visa. You are a US citizen. You don't need a visa. If you were to open this business tomorrow,
How much do
how
you need?
much would you need to invest?
Right.
So all of a sudden they know because when they ask you, then you ask them and say, I don't know. Well, of course they know, right? Or they can do a quick math. But that asking, framing the question that way has been very effective, right? So and even if they cannot come up with a number, we do an exercise. And okay, let's say that you're going to be opening a restaurant. Okay, you need a commercial space, you need the licenses, you need to remodel, you need the equipment, you need inventory, you need marketing, so how much would that be? Let's put a number on that and then see if we feel that that amount is still low, because it may still be low, especially for companies that provide services like consulting service or any other type of service. So great. Well, it's 1:06. I want to thank you, Jacqueline, again for joining us today and for your wisdom and sharing your tips on how to present those cases in a way that they result in approval, or at least maximize the chances of approval, right?
Thank you, Marco. Thank you for having me. It was great. I enjoyed chatting with you, and I hope it was helpful. If you need anything else, or if one has any questions, please feel free to reach out.
Perfect. Thank you. Thank you. Likewise. Have a nice rest of the day. Bye bye.
Bye bye, everyone.